Thank you so much for listening to this episode of Earrings Off. We want to invite you to subscribe, rate, and leave us a review. You can find us on Facebook at Earrings Off Podcast and on Instagram at The Earrings Off Podcast.
Welcome to Earrings Off. I'm Lou.
And I'm Teresa. Let's get started.
Good morning. We are here today with Kanisha Atkins, who is joining us. And of course, I have also co-host Teresa with us from Earrings Off. And we are excited because today we get to speak with someone with a lot of experience. Miss Atkins is an attorney. She's also a social worker. So she brings a wealth of knowledge to our show. And so we're interested in speaking with her and excited about what she's going to share in the area of child support enforcement. So again, welcome, Kanisha. Now, would you like to share, can you share a little bit about yourself?
Yes. So first of all, good morning to both of you, Lou and Teresa.
Good morning.
And thank you so much for having me on Earrings Off. So I am Kanisha L. Atkins, and I call myself a professional hybrid. And what I mean by that is I am, as you said, an attorney, licensed and in good standing.
All right.
And that means a lot.
Mm-hmm. Absolutely.
Licensed and in good standing in the Commonwealth of Virginia. I am also an ordained Baptist minister.
Yeah.
And I have been ordained for probably almost 30 years, active in the local church and also in the community.
Wow. Didn't know it was that long.
Yes.
Yeah.
I was ordained in 1997, but I started preaching in 1992.
Okay.
So shortly after coming out of law school, I started being active in ordained ministry.
Mm-hmm.
And then, as you also said, I am a social worker. And just for those who may not understand that there are different types of social workers, I am a clinical social worker, which means I deal with providing biological, psychological, spiritual counseling, as opposed to the social workers who work with policy and things of that nature. So I'm also an author. I have 2 books out. One is called Help, There's a Judas on My Job. 9 Steps for Surviving Workplace Betrayal.
Okay.
And the second one, yes. And the second book is Less Than Virtuous, More Than Capable, Affirmations for Everyday Women. And what I do in that book is I draw from the named women in the Hebrew Bible, or what some people call the Old Testament. And again, as I said, I'm a professional hybrid. So because those women are often given a bad reputation, I look for what can be affirmed in those women, such as Eve, Sarah, Rebecca, and then many, 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 many names that we have never heard, but they're in there.
Okay.
And so I use what I call my, as a preacher, my sanctified imagination. And I tell the stories with the women as the protagonist. And I highlight their strengths, which is something that I pull from my social work background, where we deal with strengths-based therapy.
Okay. Wow.
I'm a sister, a daughter, an auntie, a friend, a cousin, Yes, all of them.
Yeah,
So that's a bit about me. Yeah. And I've worked in state government in the Commonwealth of Virginia because, again, I am licensed to practice law in the Commonwealth of Virginia. And I've also worked in state government, not as an attorney, but in various capacities. And one of the areas in which I have worked is assisting with child support enforcement. I do have extensive experience working with child support enforcement.
Yeah. Absolutely,
Okay.
and we're excited that you bring that. But before we go to that, can you just tell us a bit about what was the impetus to the betrayal, your book that you authored? I just want to, before we get into that.
Right. We might need to do a whole
I
session
know,
on that,
right?
right?
No, because when you said that, I'm like, oh, I already know that. I already been through, lived that, bought the book, all of that. Yeah.
So the impetus for the book was actually a betrayal towards me by my, at that time, administrative assistant. It was a job that I worked in. I was a deputy director of equal opportunity programs for a major university.
Mm-hmm.
And my administrative assistant, 3 months into my starting the job, started betraying me. However, I thought it was someone else. And so what I did when I was told that my contract would not be renewed, and I felt like, okay, what am I supposed to do now? How am I to get through this? And I still had to work out my contract, which still had a year on it. I had to do some type of therapy for myself.
Right.
And so it's not really journaling. I really started writing a book on betrayal. And what I did, again, using that professional hybrid, multiple hats, as a minister, I looked at the relationship between Jesus and Judas in the Bible, not so much as ministry, but as a working relationship. And what could I pull from that working relationship in which Judas betrayed Jesus? What lessons could I pull from that and share with others?
Wow.
Now, the book sat, I do want to say this, the book sat for like 10 years after I wrote it. It was very short, maybe 5 chapters. It sat for about 10 years, and when I picked it back up, I added about 4 more chapters, thinking in retrospect, lessons that I had learned. Because the first 5 chapters were written in real time while I was still dealing with it. So that was the impetus of that book.
Wow. I tell you, that's amazing, because actually yesterday I got a call from a former mentee, someone that was on my staff at one time many years ago, and she recently had something that sounds very similar, so much so to the point that they weren't going to renew her contract. And she and I were talking about trying to come up with a strategy to address this issue that she was having, and it was very much just a betrayal, of her, and how hurtful that was, and the unexpected source of it. So just went through a conversation with her on yesterday about that. So,
I would definitely recommend the book. I give what I believe are practical steps that the person can take, even from the standpoint of trying to understand what motivates a Judas, what motivates that person.
Right.
How can you navigate through it if you still have to stay on the job?
Right.
And then how do you navigate even once you leave the job and you step into your own personal world?
Right. Wow. Okay. Well, you certainly, you've done a lot, and very accomplished, and we're excited again. And so we're gonna just jump right in. So can you tell us then, what is child support actually for? What is it supposed to cover?
So child support is to support the child, which sounds very straightforward, but many times people don't understand that it goes beyond buying clothes and food.
Okay.
I like to use the analogy of the child being a roommate. So as a roommate, that roommate is going to pay for utilities, a portion of the utilities. The roommate is going to pay for whatever costs are associated with living in that house or apartment, rent or mortgage, maybe insurance, just a lot of things like that. So it goes beyond just taking care of the physical needs of the child by way of eating and clothing. It is everything that is needed to support the child.
Okay. All right.
I've never thought about it like that. That's good. Thank you for sharing that.
Most people don't.
Yeah.
No,
go ahead.
I have talked to people who are being required to pay child support, and they will make statements such as, well, I buy Pampers.
Yeah.
Or I buy shoes. I tell them whenever they need some clothes, just let me know. But it's beyond Pampers and Similac and shoes and jackets.
Yeah. Yeah.
Wow. Yeah.
That's very, very helpful. Yeah.
So who can apply for child support, and how do you apply for it?
So the person that applies for the child support is considered to be the custodian. The person who applies for child support is the custodian. That means the person with whom the child lives. So normally it is a biological parent, and that parent would be called the custodial parent. It could be the father or the mother, because we do live in a time where fathers are the custodial parents as well as mothers being custodial parents. But the custodial party may not necessarily be a parent. It could be a relative, an aunt, an uncle, a grandparent. And so that's who can apply for child support. And again, I have worked in a particular state. In the state that I have worked in, the person would go to the Division of Child Support Enforcement, and this would be in any state, whatever they call it, whether it's the Office of Child Support Enforcement, the Division of Child Support Enforcement, the Department of Child Support, whatever they call it, the person would go and fill out an application. And apply for what are known as benefits. Child support is considered a benefit. And so that's how it's the process.
Okay. So now, so, but if you live in Virginia and you're the custodial parent in Virginia, but the other parent lives in California, can you apply?
Absolutely.
Okay.
Absolutely. I do want to mention a second way that child support enforcement can be applied for. You can always go through the court system.
Okay.
So there is an administrative way to apply for child support, but you can also petition the court, usually a juvenile and domestic relations court, and go through the court. And an administrative support order or a judicial order can either or can be established for support. Now, if the custodial parent lives in Virginia and the non-custodial parent lives in California or another state, what happens within the United States is there is an act. I'm going to see if I can remember what the initials stand for, because you know how it is when we work in these jobs.
Oh, yeah.
We're accustomed to using acronyms.
Yeah.
So the acronym is UIFSA, UIFSA, which, if I am remembering correctly, stands for United Interstate Family Support Act. I believe that's what it stands for. So what happens is Virginia as in the state, may have a person who comes to apply for benefits. The custodial parent applies for benefits, and the non-custodial parent is in California. Virginia's Child Support Office will reach out after they have established the order. They will reach out and possibly ask California to enforce the child support order. And Virginia also has access to many different national networks to get income for both parties.
Okay.
Information regarding employers and employment. So states usually work with each other. So you don't have to live in the same state as the non-custodial parent in order to apply for child support.
Okay. All right. Good information.
So that is good information. So that means that the non-custodial, the custodial parent doesn't have to necessarily know the income of the non-custodial parent that will be paying the child support. So how do they find that out? Is it through the courts that you have to go through to get the benefit for the child? You understand what I'm trying to say? Like, if a person doesn't know the other parent's income, if one parent doesn't know the other parent's income, what can they do to verify or find out what the other parent's other income is and their ability to pay?
It is not the responsibility of either party, custodial party, non-custodial party. It is not their responsibility to present that information. If they have it, great. They may have pay stubs. They may have W-2s. They may have that. Mm-hmm. However, the agencies do not rely on the parties. The agency will get the name of the employer and can contact the employer. As I stated a few minutes ago, there are different connections that the agencies have. For example, employment commissions. Employment commissions are generally required to report quarterly earnings for all of their, employers are required to report earnings for all of their employees to employment commissions. So in Virginia, the Child Support Office can look up income for the party in the Virginia Employment Commission's database. There is also a national database. I believe it's called the National Database for New Hire. That has income information for people. The agency also reaches out to the parties. And again, when filling out the application, the parties list information about themselves. And so the agency will reach out to the non-custodial party, will ask the non-custodial party to fill out this information. And in that information, the non-custodial party provides what he or she earns. And also has to provide verification of those earnings, such as if I say I make $1,000 per week, I need to provide a pay stub to show that.
Okay. Well, Kanisha, as an attorney then, if you hear people say, well, you know, my boo and I are getting along just fine, we don't even need a child support order. So are there instances where, you know, maybe the parties can agree, that's not even, if we agree to a specific amount, that an order is not needed, that they don't need any type of administrative action or going through the court?
Parties can absolutely do that. And that is the best thing I believe that can happen. Just like if you're dealing with custody.
Right.
It's better if the parties can work it out. But when the parties can't come to an agreement and the person who has physical custody of the child or children feels that the person who doesn't have physical custody is not going to provide adequate financial support, that party has a right, the custodial party has a right to go either through the courts or through the administrative agency. Now, once that process starts with the administrative agency, the party cannot then come back and say, well, we've come to an agreement on how much the non-custodial party is going to pay. The agency is not required to take their agreement at that point.
Okay, once it starts.
Right. Now there have been some changes where before the agency puts an administrative support order into place, there have been some changes that the agency will act as a type of mediator to help the parties come to an agreement. But again, that is prior to an order actually being put into place.
Okay. All right.
So at what age does the child support obligation end?
So I'm going to give you a lawyer answer.
Okay.
Child support generally ends at 18 years of age.
Okay.
However, there are some other factors tied in. So again, I'll speak from the standpoint of one particular state. 18 years of age and the child is still in high school. So that would mean that once the child graduates from high school, support is no longer due.
Okay.
All right? 18 years of age and still in high school. Again, there are some other caveats, however. One, I'm thinking of a particular law that allows for child support to continue beyond 21 years of age. But that is when the child has been medically determined by a physician to be completely and permanently, totally and permanently disabled, whether mentally or physically, requiring that there always be a caregiver present. And I believe there was another criteria. There was another criteria. In that particular instance, child support goes beyond 18 years of age. So generally, it is 18 years of age. That is the cutoff, and there may be some other criteria tied in to 18 years old.
Okay. Now, but if the child was living with one parent, say parent A, and when the initial order was made for payment to that parent for child support, and then for whatever reason it changes, the child starts living with the other parent, parent B, does then parent A still have to pay that child support? All
right, so child support is paid by the non-custodial to the custodial.
Okay.
So whoever the child is living with, that is not the person who pays, that is the recipient.
Okay.
So if the child is living with parent A who receives child support, and then the child goes to live with parent B who had been paying child support, it is up to the parent to contact the agency and let the agency know, or if it is through the courts, let the courts know that custody has changed.
Okay.
And then they can go through the process of changing who the new payee is. So now maybe it's no longer parent A who is receiving, maybe parent A is now what we call the obligor. They are obligated to pay parent B.
Okay, so they have to make sure they take action to notify either the administrative agency or the court. Okay.
Absolutely. It will not be automatically done for them.
All right. Okay.
But in that case, what if the parent that was initially receiving the child support not able to or doesn't have the income to give to the parent, the new parent, the new custodial parent B?
Right, I understand what you're saying. So child support is calculated based on earnings from both biological or legally adoptive parents, because we know people can adopt children.
Right.
So the child support is based on their income. And there are many instances that I have seen where one or both of the parties did not have income that was reported, did not have income. When I say reported, I mean officially through, again, like an employment agency or the national database for new hires. They didn't have income that was showing up. It could be that they are not reporting any income. So when they fill out the application that they're asked to fill out, they put they don't have a job, they don't have any income. When that happens, it more than likely will end up being a minimum order. So it doesn't mean that you don't get to pay child support. It means that your order will be a minimum order, and so that's how that works.
Okay. So how is child support determined in instances where there's shared custody?
In instances where there is shared custody, child support under, I'll use the Commonwealth of Virginia as an example, the agency will refer the case to court. And the court will determine how that works. And I want to make it clear, many people say, well, we have shared custody. Shared custody is a legal term of art meaning that you actually, let's use the non-custodial and custodial parent. All right. So let's say that the non-custodial parent has the child residing with him or her. Under the laws in the Commonwealth of Virginia, it is at least 90 calendar days out of the year. That is what shared custody is. It is not simply, I pick up the child from school, give the child dinner, and get them back to the custodial parent. It's 90 full calendar days at least. So shared custody looks at the amount of time that the child is actually in each house and not necessarily the responsibilities that you give towards the child.
Now, that's very helpful because that's very precise information for people to have.
Yeah.
Yeah. So
I would also like to add that shared custody is not the same as legal custody. Legal custody means that the parent has the right to be involved in making decisions that benefit the child. That is legal custody.
okay.
Many parents will say, well, I have legal custody, but they may not have physical custody
Right.
or shared custody.
Okay.
And child support is not determined by legal custody.
All right. Okay.
It can get very complicated.
Well, that's why we've got Attorney Atkins on the case. So now, when a child support order is entered, is there consideration for bills or living expenses of that non-custodial parent or the parent?
I'll give you my attorney answer again.
Okay.
Yes and no.
Okay.
No, bills such as living expenses, rent, mortgage, car payments, insurance, those types of things are not factored in.
Okay.
However, if the party has another child under the age of 18, either their biological or adopted child who lives in the home with them or for whom they are paying child support because that child lives in another home, then there is an adjustment made in that party's gross monthly income.
Okay.
Now, I use gross monthly income in the Commonwealth of Virginia. That is where we start. We start with gross monthly income. Some other states may start with available income, which is your income after certain things are taken out.
Okay.
In the Commonwealth, we start with gross monthly income. And if you have other children, biological or adopted, residing in the home with you or for whom you pay child support, then there is an adjustment made to your gross monthly income, subtracting an amount out, leaving you with available monthly income.
Okay.
There are a few other things that will be allowed as an adjustment, but none of them include living expenses.
Okay. All right.
Okay, so how is child support collected?
Generally, child support is collected through income withholding. So when the non-custodial party is obligated to pay, there is communication from the Child Support Enforcement Agency to the non-custodial parent's employer, instructing them to withhold a certain amount per month. If that person gets paid weekly or bi-weekly, then they just take the monthly amount and divide it up by however many paychecks that person gets per month, and they withhold that amount. It is then transmitted to the Child Support Enforcement Agency, and in the beginning of the month, that money is disseminated to the custodial parent.
Okay.
There are occasions, primarily when the courts are involved, where the courts will allow the non-custodial party to make direct payment to the custodial party. But many times, probably most times, the courts and the agencies will go through that automated type of collection, working with the employer to the agency, and then agency to the custodial parent.
Okay, well, I think you just cited one way that a child support order can be modified, like if the person has, the non-custodial parent has another child. But are there other factors which may be cause for a modification to that order, a change in that order?
Yes. If a parent has another child,
Okay.
another child is given birth to,
Mm-hmm.
that can be a reason for a modification in an order.
Mm-hmm.
But it is up to that parent to initiate that modification. If there is a significant change in income, and significant is laid out specifically in policies and laws. If there is a significant change based on what the policy or the law says, that can trigger a modification.
Okay.
As we said, also, if there is a change in physical custody, that can trigger a modification.
Mm-hmm. Mm-hmm.
Again, triggering is not automatic. It must be an action taken by the person who wants the modification.
Okay. All right. Okay.
So I guess in that it factors or it's considered if the parent loses a job or gets a new job, right? So how then does the amount automatically change, or do you have to go back to how is that addressed if a parent loses their job or gets a new job?
If the parent's income changes either by way of losing a job or getting a new job, or having the same job and getting a raise.
Mm-hmm.
Wow. Okay.
All right? In any of those types of things, yes. What would happen is it would go through a review and modification process. So they would look at the income for both parties again. They being the agency, they would look at any adjustments that need to be made if there are other children in the home. So it's almost like the same process that the agency would go through if it were an initial order. But now what you're doing is you're looking at the new set of circumstances. And going through the same process and procedures with the new set of circumstances. There is also the possibility that if nothing changes, nobody has any other children, nothing changes on the job, but so much time has gone by, a review and modification can happen that way as well. So if it has been 3 years or 5 years or something of that nature and nothing has changed, the agency can initiate a review and modification as opposed to one of the parties initiating it.
Okay.
Well, I like your earlier point was helpful when you said to think about the child as a roommate. Because so often you hear people saying, well, I'm giving money and they're not using it for the right thing and they're just taking my money and the child's not getting, when I get with the child, I still have to buy a jacket or something. So, but if there's an instance where the non-custodial parent that's paying support believes that the payments aren't being used by the other person, the custodial parent, what can be done in those instances, or if anything can be done?
So let me ask you if you would give me some clarification on your question. When you say the payments are not being used for the child, are you saying the child is being neglected?
And so that's the point. That's the larger point. When you talked about earlier the roommate, because, and I'm certain you probably heard this, it's common for people to say, I'm giving this money, but the child, when I see the child, I have to then pay for maybe some new sneakers. I have to buy the child things. And so you often hear that. But what I understand you to say is that's not the determining factor for them to consider whether the funds are being used appropriately for the child.
In a set of circumstances like that, I personally think, and just from my observations, I think that is beyond a child support issue.
Okay.
That sounds to me more like a custodial parent who does not want to send the clothing over to the non-custodial parent when the child goes over there. It doesn't sound like necessarily that the custodial parent is not using the funds to provide for the child. It could just be that those things that are being provided, such as clothing, are not used when they go to the non-custodial party. All right. If the non-custodial party believes that funds are not being used to the detriment of the child, I believe that gets over into a child protective services issue.
And that's the clarification. Yeah, that's very helpful. Because you do, well, at least I do. I've heard that many times from non-custodial parents. And it's like you say, you can say that, but if that's true, if there are some deficits, if the child is not being taken care of, that's a whole nother issue.
Exactly. Yeah. Exactly.
Okay. All right.
What if a custodial parent feels that they're not getting enough money to support the child? Not saying that they're using it for themselves, but just not enough to make sure that that child is getting supported in the way that that the child needs. So what happens? Is there an appeal process?
All right. So I'll have to. What I'll do is I'll go from whether the order for support is established by the court or whether it is established by an agency. If a child support order is established by the court, the party must go back through the court if changes need to be made. The agency cannot amend a court order. Now, I'm speaking again just from a particular state. I would suggest that people check with the laws in their particular state.
Right.
Okay.
If the order is established by the agency and the order is sent out to the custodial and non-custodial party, and either or says, this is not right. They used the wrong amount for my income. I have another child. They didn't include that child on here. I pay for insurance. They didn't include insurance because medical support is part of the child support obligation. If that happens, they have a certain amount of time, as with any appeal. Appeal rights do not last indefinitely. There is a limitation on when you can file. So once they receive the order in the Commonwealth of Virginia, they have 10 days to file an appeal for the administrative support order. Other things, such as if they were appealing an enforcement action, such as their taxes were withheld, their tax refund was withheld, they have 30 days to file the appeal. But they have an appeal period in which to file. And when that appeal gets before the hearing officer who will make the decision, that hearing officer will determine, number one, is it a valid appeal? Looking for such things as, if they're appealing an administrative support order, did they make it within the 10-day window? If they didn't, it's invalid and there will not be an appeal. There will not be a hearing or a new decision. Let's say they're appealing an enforcement action, such as a bank account that's been placed on hold, or taxes that have been seized. The hearing officer will have to validate that appeal as well. The hearing officer will look for, is there a mistake of fact? Are you alleging a mistake of fact? A mistake of fact is you have the wrong non-custodial party. You're withholding my funds, but I'm not the person that you think I am.
Okay.
Mistake of fact is you made an error in how much I owe. What arrears? What has accumulated on the account? You're saying I owe $10,000. I only owe $1,000. You've made an error.
Okay.
And then there are certain laws that will exempt enforcement actions. The hearing officer validates the appeal, schedules and holds the hearing, and during the hearing, it is not simply a telephone conversation, because we're in the age of COVID-19 right now.
Right.
And so a lot of things are being done by teleconference or video. It is not just a conversation. It is a hearing.
Absolutely.
And that is what many custodial and non-custodial parties don't realize. It's not just a conversation. This is the hearing officer is like the judge. You can represent yourself, or you can have an attorney. You can have an attorney in this process who will present testimony and evidence, either you or your attorney. If you're presenting testimony, you need to have documentary evidence to back this up. Because the hearing officer does not just take your word. There has to be independent evidence to validate what you are alleging. The agency is also involved in that appeal, where they present their evidence and testimony explaining how they came up with the order. And then the hearing officer takes all of the evidence and testimony, reviews all of that, researches and reviews laws and policies, and makes a written decision, sends it out to the parties, non-custodial and custodial, and they also have a right to appeal the hearing officer's decision. To, again, if it's an administrative support order, they generally appeal it to the Juvenile and Domestic Relations Court. If it is a tax issue, whether state or federal, they generally appeal that to circuit courts.
Okay.
Wow. Okay. So we've talked, I just want to make sure we cover some points that people may need clarification on, and that's about if they fail to pay, the repercussions, because we know that, that their income, they can have their pay garnished, they can, their tax refunds, they can have those taken. But something recently, I attended a meeting, they hadn't thought about it, but they said that there was an increase in child support payments as a result of the stimulus checks. And I hadn't thought about that that was impacting people as well. So what are the ways that people need to be aware of that if they don't pay that, that money that they can make sure they get their money for the support?
All right, so if a person, the non-custodial party, does not pay the support obligation, it accumulates and becomes what's known as arrears. ARREARS, arrears. Arrears can be just the basic obligation amount. In some states, they also add interest and fees onto it. And if the person doesn't pay over a certain amount of time, again, I would suggest that people look at the laws in their states to see what that amount of time is. What can happen is, like you said, their paychecks can be garnished, for lack of a better term. Well, actually, they don't garnish the paycheck. What they do is they will put a hold on a bank account.
Okay.
They'll find that there is possibly a source of funds from which they, being the agency, they'll find there is possibly a source of funds from which they can collect the arrears, and a hold goes on that account.
Wow. Okay.
When that hold hits, the person has a certain amount of time to appeal it. And then you go through that appeal process that we just talked about. With regard to, let me just mention a few other types of ways that the agencies can collect, and then I'll get to the stimulus issue. The agency can also do things like suspend driver's licenses.
Wow.
Right.
Didn't know that.
Get professional licenses suspended.
Wow. Yeah.
So if you are a barber, a cosmetologist, a lawyer, a doctor, they can move in the area of getting those licenses suspended.
Wow.
They can make reports to credit agencies. They can get your passport withheld or revoked. So there are just a lot of different things that can happen when you don't pay your child support. And I want to be clear, I don't believe these things happen immediately.
Okay.
So one missed payment does not result necessarily in a license being revoked or suspended.
Okay. Right.
Okay.
Yeah.
Now, with regard, yes. did you have a
And
question?
I think, let me clarify, the stimulus, the increase in the payments, that was from people, I think, getting those stimulus checks and actually making some payments to child support. I think there's been an increase.
A couple of things happened with the stimulus checks.
Mm-hmm.
The $1,200 that went out per person.
Right.
If you were a non-custodial party and you had paid your taxes, that's how they determined who'd get it.
Right.
You're a non-custodial party, you had been filing your tax returns rather, I'm sorry. You were filing your taxes, and you were granted a $1,200 stimulus payment, you didn't get it.
Okay.
It went towards your child support arrears because you were in arrears.
Okay.
Now, if your arrears were less than the stimulus payment, then you would get the balance.
Right. Okay.
Okay.
The other thing that I think happened is offices that deal with like unemployment benefits, they increased the amount of unemployment benefit.
Oh, okay. Okay.
And that might be what you're thinking of when that unemployment benefit amount went up. If there was a modification made, that increased amount of unemployment benefit caused their income to look higher, and that's what the new order was based on.
Yes, that makes sense, because I was a little confused by that. Like, how did that happen? But okay, that's very.
I have a question. You mentioned that in some cases, in some states, they charge interest and fees on arrears. Now, does that go to the child? Who gets the interest and the fees?
That's a very good question.
It may be.
I would imagine that there is a division of where it goes. I would imagine that the basic obligation amount goes to the custodial parent. Interest and fees, I would have to check, but I'm thinking it probably goes towards the government.
Yeah, it's probably processing. Okay. Yeah.
Processing fees.
Additional manpower.
I do want to bring up one thing that has like two branches, just in case you don't get to it. Another way that child support can be initiated is if your child goes into foster care.
Oh, yeah.
If your child goes into foster care, that's not a freebie. Social Services is required to then contact the Division of Child Support Enforcement and require that they open up a child support case. So not only will the person have to, if your child goes into foster care, that is handled through the departments or divisions of social services. Social services works with the departments or divisions of child support enforcement. And if the child, again, usually in foster care, they're under 18, and we talked about when child support ends.
Right.
So if the child is under 18 and goes into foster care, then both biological parents are now considered non-custodial parents. And they are both obligated to pay child support.
Interesting. Right? Yeah, I didn't know how that worked.
Also, if your child is taken into custody in juvenile justice, your child becomes incarcerated as under the age of 18, child support can be opened up for the non-custodial parents to pay child support to support that child. More than likely what happens is the money that is collected for child support goes back into those systems, kind of like a reimbursement.
Right, yeah.
But many people don't know that. Another thing people don't know is when they apply for TANF, Temporary Aid for Needy Families, that becomes a debt that is owed back to the state. So Custodial parent has the children, applies for temporary aid for needy families, known as TANF. That TANF has to be paid back to the state by the non-custodial parent.
Wow.
Wow.
And if the child is under 18, a current obligation is also opened. So the non-custodial is paying current support, which goes to the custodial parent, and is paying back the TANF, which goes back to the municipality.
I did not know that. Well, those
it's an eye-opener. It's an eye-opener.
It's very much an eye-opener.
Yeah.
And it's really an eye-opener for the parent who applies for TANF, because what I hear many, many times is that they weren't aware that a child support case was going to be opened.
Right. Yeah.
I will hear from a non-custodial parent who says, well, he said he didn't want child support, or she said she didn't want child support. And I have, heard it explained to them that person didn't initiate child support. Right. That person initiated getting TANF benefits, which automatically results in a child support order being opened because the child or children are under 18.
And then when you think about interest and fees, you wonder how people are ever going to get from under that,
Right. Yeah.
Yeah.
Yeah. And then you think about people who have, sitting here, I was thinking about people who have so many children that they're responsible for. And I'm talking about the non-custodial that have to support the custodial with, and the impact that has on their lives.
Long-term impact.
Yeah.
Absolutely.
Yeah.
Absolutely.
Yeah.
There are many non-custodial parties who have multiple children by multiple partners.
Yeah.
And it's heartbreaking to see so many orders for one person. However, you have to remember that there are consequences to choice.
Yeah. Well,
absolutely.
And remember that the children are innocent, and they have to be taken. They have to be taken.
And they have to be taken care of.
They have to.
And they didn't ask for it. Yeah.
Yeah. And many times people, they just think, well, the government can take care of everything. But I understand that there are, consequences, and that, particularly when you apply for certain aid, that has to come from somewhere.
Right.
So, yeah. Wow. Well, those are all of the questions that we have for you, Attorney Atkins. Do you have anything that you want to share with our audience before we wrap up?
I think we have been very thorough and very, very thorough in our discussion of child support. Again, I strongly suggest and recommend that if people have questions about child support, you can always contact and consult with an attorney. Mm-hmm. You can also go to the websites. I would imagine every state has a website that deals with child support. You can contact your local agencies to get information. But one of the things I would just really encourage people to do who are involved in getting or paying child support is to remember that this is your life, and you must take the initiative in your life. You must not wait around for someone else to remind you. If you have an appointment, you must check your mail. It is your responsibility. If your address changes, if you fail to do an update on your address, you might find yourself in a position of where your support has gone up and you never responded to give them your new information. So that's the main thing I would want people to take away. This is your life when it comes to paying and receiving child support, and you need to stay on top of it.
Right. Okay. Well, thank you. Thank you so much for sharing this information. I'm sure that it has it's certainly been valuable and will do much to help people prepare and understand going forward this issue. So thank you again, and we wish you all the best.
Thank you so much.
Thank you.
Have a good day.
All right, you too.
Thank you.
Thank you. You too.